All right, good morning, everybody. To launch off this conference on LawFare, it is my great pleasure to introduce you, if you haven't met him before, to the dean of this wonderful school that's hosting the conference. We are very fortunate here at Case to have a dean who is a Rhodes Scholar. He's probably the only dean in the world who played basketball with Bill Bradley on a championship team out in Oxford, right? And he's been doing wonderful things here at the school. He's been very supportive and very involved in our international law program. And so it is quite appropriate that he welcome you today. Bob Rossin.
Thank you, Michael. I'm delighted in my role to welcome everybody here. It's wonderful to have all of you joining us for what will be an extraordinary day, and I especially want to welcome our distinguished panel of speakers. I envy all who will attend and listen to the perspectives of the folks we have been able to assemble. A couple of comments on Michael's generous introduction. The first is that I peaked very early in life, and I've been rapidly sliding downhill and hoping that I'll get to the end of whatever I'm supposed to do before I really hit bottom. The basketball piece is, as you can tell by looking at me, I'm small, but I'm also slow. So the fact that I was playing with Bill Bradley gave us some opportunity to win a game or two, but I want to just put all that in perspective for all of you. Over the next several hours, you will all learn about, quote, LawFare, which has been defined as using law and legal institutions in place of military tactics, which sounds to the layperson like a logical way to proceed. Then you think about the thought-provoking tagline for the conference as listed at the top of the brochure, quote, "Are America's enemies using law against us as a weapon of war," end of quote. Today, our expert panelists will explore the history and debate around the meaning of the term lawfare. They will look at lawfare in three different contexts. First, with respect to international war crime trials. Second, with respect to the Israeli-Palestine situation. And finally, with respect to America's struggle against terrorism. And they will ultimately consider how America and its allies should best respond to lawfare. This is exactly the kind of conference which we in our Frederick K. Cox International Law Center are delighted to host. Last year we hosted a conference titled After Guantanamo, which examined what to do with Guantanamo detainees and the officials accused of mistreating them. We've also held several important expert meetings, like the one that will take place tomorrow. For example, in 2008, we had a meeting about the International Criminal Court and the crime of aggression, which helped develop the compromise proposal that was adopted by 111 countries in Kampala this summer. This is all part of an ambitious international law program here, which has attained national and international recognition over the years. I encourage you to take a look at the Case Global brochure, which you'll find on the registration table, to learn about other ongoing international activities and projects. We could not do all this, of course, without resource support, to state the obvious, but that's what deans are supposed to do, so I've just done that. Our international program is very fortunate to have been endowed by generous contributions from the Gund Foundation and the Bruce Klatsky Foundation, and we're especially grateful today to the Wolf Family Foundation, whose generous grants have made possible this conference and ones like it over the past 8 years. We also thank the organizations who are co-sponsoring this event: the American Society of International Law, the American branch of the International Law Association, the International Education Committee of the American Bar Association, the International Association of Penal Law, the Inamori International Center for Ethics and Excellence, and the Public International Law and Policy Group. Now, we have much more to do, or we have many more ambitions here at the Cox Center. As you might have seen if you've looked at the Case Global brochure and at the back of it, we are in the midst of a fundraising campaign to honor the legacy of Henry King. As many would know, he passed away last year after teaching at Case and directing our Canada-U.S. Law Institute for 30 years. Henry had been a Nuremberg prosecutor and Honorary General Counsel of Canada to Northeast Ohio, among other other important positions. He was an institution builder, and the purpose of the campaign is to ensure that the institutions to which he dedicated himself will endure even after his loss, those being the Canada-U.S. Law Conference, the Niagara Moot Court Competition, and the War Crimes Research Office. And we hope, with your help, they'll continue to thrive. If you can help us with this endeavor, we'd be very grateful to you. Now, as a final point, it should be obvious to everybody in the room, but an event like this doesn't occur unless you have an inspiration and a leader to make it happen. And we happen to have that here. His name is Michael Scharf, and it's my pleasure to turn the podium back to him. Michael.
Well, the topic of our conference today, LawFare, is literally ripped from the headlines. The ACLU just sued the United States government over the use of unmanned drones. And just yesterday, there were press reports of a 5th drone attack in the last 7 days in Pakistan and in Afghanistan. The first trial before the Al-Qaeda military commissions of Omar Khadr, the 15-year-old who is accused of lobbing a grenade at an American soldier in Afghanistan, is scheduled to recommence next month with the beginning of the prosecution's case. And the defense assertions that the trial violates the Geneva Conventions have been declared by many as a form of lawfare. Then last week, there were reports in the press suggesting that a lawfare campaign is being waged by Palestinians in advance of the new round of the Israeli-Palestinian peace talks. The newspaper reports that the Palestinians had been launching a series of lawsuits against Israeli officials and members of the military in courts throughout Europe in order to affect the peace process. The Obama administration, in turn, has decided to switch tracks in dealing with the country of Burma, from constructive engagement to sudden support for a UN investigation of atrocities, potentially leading to international prosecutions. At the same time, the Obama administration has created a new rule of law field force in Afghanistan that's being commanded by a friend of many of ours, Mark Martins, really bringing lawfare to the forefront of that conflict. So lawfare is everywhere, and it's timely, and it's important, and most of us are thinking, what in the world is it? So today, this conference is going to answer several questions. First of all, what is lawfare? Second is lawfare a useful concept, or is it just code for things we don't like? Third, are there legitimate and illegitimate types of lawfare, and how do we distinguish between them? And finally, as Bob just mentioned, if our enemies are using lawfare as a weapon of war against us, how should we be responding? By employing our own lawfare or otherwise? So we're going to be learning a lot in the next couple of hours. This is the first academic conference to tackle this issue. It's being webcast around the world. There'll probably be several thousand people listening in on this. In addition to the 120 of you in this room, there's another 120 upstairs watching from our overflow room. And tomorrow's experts report, as well as the conference articles, will all be published in a special journal of our International Law Journal. Out in January, and because of the generosity of the Wolf Family Foundation, those will be made available to over 1,500 experts and government officials and people around the world who are going to be wrestling with this question of lawfare. So today, the wrestling match begins, and before we start with our first panel, I would like to introduce Michael Kelly, who is the president of one of our co-sponsoring organizations, who use this occasion also as their annual meeting. And they begin every year with the presentation of 2 special awards. I turn the program over to Mike.
Thanks, Michael. L'Association Internationale de Droit Penal, and that's the extent of my French, is an organization of penal lawyers, scholars, and judges founded in 1924 in Paris. It's still based in Paris, and it has consultative status with the United Nations. It publishes the Review, which contains updates in the field, articles by members, hosts annual meetings in Paris, and organizes congresses every 5 years, the most recent of which was in Istanbul. The U.S. National Chapter, which was founded by Sharif Bassiouni, whom you all know, several years ago, actively participates in the life of this organization. And one of the things that we do every year is recognize the outstanding book of the year and the outstanding article of the year published by our members. And it's my pleasure to present the Outstanding Book of the Year Award for 2010 to Bill Shabas for his book, The International Criminal Court, A Commentary on the Rome Statute. Bill? I don't think you're required to speak. Next, our Outstanding Article of the Year Award for scholarly contribution to the field goes to Layla Nadia Sadat for her article, The Nuremberg Paradox. This article appears in volume 38 of the American Journal of Comparative Law. Congratulations, Layla.
Thank you, and I won't speak.
We co-sponsor symposia like this each year and codification efforts for international criminal law. If you are interested in becoming active in our organization, I'll pass around a sheet where you can put your email down and I'll contact you. Thank you, Michael.
And now the show is about to begin. Let me tell you that in order to keep this lively for those of you in the audience, so you don't start to nod off if you don't have a lot of coffee during the day, we have a number of different formats. The program is going to start with 2 speeches that will just describe the history of the term and what its meaning has evolved over the years of lawfare. Then after that, we are going to have several panels. Oh no, then we have a debate, and the debate is going to be like a presidential debate, 2 on each side. There are going to be rebuttals. It's going to be moderated by one of our famous radio personalities from town, Dan Malthrip, and he will ask follow-up questions like they do in presidential debates. That ought to get us going. Then there are 2 panels in a regular traditional format where the speakers will speak, followed by questions from the audience. So that's where you all get to get involved. Ask as many questions as you want. We'll try to keep enough time so there will be plenty of time for that. Following that, at the end of the day, there's going to be a roundtable discussion, which is going to be in crossfire format. So that'll be really interesting about whether and how lawfare has been affecting the war on terrorism. So the day has many different formats, and we just begin now with a panel, no question and answer, but just telling you from 2 different perspectives of experts of semiotics, and you'll learn what semiotics means in a few minutes, of the origins and meaning of lawfare. To kick off that panel, I introduce the panelists to come up here, and the moderator, Tay Ansah, who has worked in the UN, has come to us as a visiting professor this semester from Boston, and he's been a wonderful addition to our faculty this semester, and he's going to be moderating today. Tay and the panelists.
Good morning. I'm delighted to introduce this morning our 2 panelists, our 2 speakers. The first to go is Professor Susan Tiefenbrunn, who is a professor of law at the Thomas Jefferson School of Law. She's also the director of the Center for Global Legal Studies, and her area of expertise is semiotics. She's recently published a book on semiotics entitled Decoding International Law, Semiotics and the Humanities, which has been published by Oxford University. I'm also delighted to introduce the second speaker today, who is Professor Wouter Werner at the VU University in Amsterdam. His specialty is international legal theory, and he's on the board of the Association for Semiotics of Law. He's also the director of a research group called the Boundaries of Law, which involves the study of philosophy and law. Professor Werner is also with the European Network on Constitutionalism and the Fragmentation of International Law. So without further ado, Professor Tiefenbrunn.
I'm going to stay up here because I need to get my slides up. So once you get it up, I can click. Good. Thank you, Michael Scharf, Force of Nature, who organized this and many other conferences. I'm honored and delighted to be here. LawFare, what is it? It is a weapon designed to destroy the enemy by using, misusing, and abusing the legal system and the media in order to raise a public outcry against the enemy. It's a clever play on words, a pun, a neologism, a new coined word, that needs to be deconstructed in order to explain the linguistic and the political power of this term. LawFare creates a very interesting and shocking equivalence between two words, law and war. And semiotic theory can help unpack this play on words. So in the 13 minutes allotted to me, I will apply semiotic theory to expose the meanings of the term lawfare and to try to interpret it. First, I will look at the definitions of the word law, as well as its text, context, pretext, subtext, denotations, and connotations. I'll do the same thing for the word war, in order to better understand the identity created between the law and the word in the term lawfare. The linkage of law and war is most clearly manifested in the expression of a just war, or in the elaboration of the laws of war. Both law and war enjoy power. And it is precisely this shared power that constitutes the basis of the use of lawfare as a weapon. I will look at the different techniques of lawfare and the serious impact of that usage on politics and on the whole integrity of our legal system. So next, what is law? And I can't do justice to that question, obviously. You have to look at legal theories, different jurisprudential theories of the law, such as natural law, legal positivism, legal realism, and sociological jurisprudence, each of which stresses different aspects of the overarching concept of law. Natural law is divine law, lex aeterna, eternal law, unchanging law, normative jurisprudence. Positive law is changing law. It is a word derived from the Latin positum, which means established. And thus, positive law is laws, codes, statutes, treaties that have been established by human beings. Legal realism is a theory that derives not from the idea of rules or principles of statutes being the nature of law, but rather on judicial decisions that derive from social interests and public policy. Sociological jurisprudence frames hypotheses on which to base general laws and the operation of law in society. In the early 20th century, following the work of John Austin, a guy named H.L.A. Hart pursued a modern positivist conception of the law and of the importance of rules, which he established in the very famous book that you all know, The Concept of Law. by adhering to the discipline and constraint of obedience, rules and the law paradoxically bring liberty to people, freedom, create liberalizing order, consistency, stability, and thus power in society. Oliver Wendell Holmes, who, by the way, was a great friend of a semiotician, no less than Charles Sanders Peirce, one of the fathers of semiotics, Holmes stressed also the power of the law when he referred back to the origin of legal procedure as vengeance. In order for you to understand the paradoxical, contradictory, and ambivalent nature of the term law, I'd like to just tell you what Holmes said about the law in a very poetic passage in which he referred to the law as his mistress, only to be wooed with sustained and lonely passion. He said, "When I think of the law," and it's right up there, "we know her in the courthouse and the market. She seems to me to be a woman sitting by the wayside, beneath whose overshadowing hood every man shall see the countenance of his deserts or needs. The timid and overborne gain heart from her protecting smile. Fair combatants, manfully standing to their rights, see her keeping the lists with the stern and discriminating eye of even justice. The wretch who has defied her most sacred commands and has thought to creep through ways where she was not, finds that this path ends with her and beholds beneath her hood the inexorable face of death." Oliver Wendell Holmes. He too saw that law has many qualities. Law can be conceived of as rules, as interpretation, as liberalizing rights, as imposing commandments, as constraining and providing duties and responsibilities. But there's no doubt, within all these different definitions that I've given you today, there's one thing in common. Law is power. So, what is war? We are told that war is hell, except when it is noble, thrilling, profitable, and convenient. The word war comes from the Middle English term wary and the Old High German term ware, both of which mean strife and confusion, and both of which clearly have negative connotations. But in the Middle Ages, the concept of war was acquiring and ennobling positive connotations. Warriors and knights were glamorized as heroes, despite the havoc and the destruction that war wreaked on civilians. The most, I think, interesting illustration of the duality of this term is from the Latin word war, which is bellum, and ironically, the declined form of bellum is bellus, which in Latin means beautiful, charming, handsome. War and law both have positive and negative connotations. In the Middle Ages, the positive connotation of war was so amazing that one writer said, "War is a joy. It is a joyous thing is war. You love your comrades so in war that when out of that there arises such a delectation that he who has not tasted it is not fit to say what a delight it is." Wars in the 17th century were very limited in objective and scope. War in the 18th century was a limited instrument of national policy. War in the 20th century, World War I in particular, was a total war. The entire population and the entire economy was mobilized for a prolonged period of time. Modern war is asymmetrical, in which the basic distinctions of battlefield and uniform are eroded. What is asymmetric warfare? It's an attempt by paramilitary organizations to erode the distinction between combatants and non-combatants, and between military and non-military targets. And because asymmetrical warfare is in direct conflict with the military terms of necessity, proportionality, distinction, and humanity, it is very difficult for us today to speak of asymmetrical warfare and just war. What are the laws of war that control and protect civilians, soldiers, and prisoners of war? I haven't got the time today to go into the history of the laws of war. Suffice it to say that there are many. There are codes. They go back to the 6th century BC when Sun Tzu wanted to regulate the way wars were conducted. It goes back to 200 BC in the Hindu Code of Manu, where they spoke of war crimes, the Geneva Conventions, and the basic principles of customary law that I spoke about a moment ago. So now let's get to the main point. We have unpacked law, unpacked war, talked about laws of war. What is lawfare? Well, sitting here today is Charles Dunlop, who was the first to coin the term, and he defined it as a process, a legal process, a weapon in modern warfare to achieve a military objective or to deny an objective to the enemy. Later, he expanded that definition, explaining that, and this is important, lawfare is the exploitation of real, perceived, or even orchestrated incidents of laws of war violations, being employed as an unconventional means of confronting a superior military power. And the definition has even further been expanded to the wrongful manipulation of the legal system to achieve strategic, political, or military power. Lawfare is effective because one lawsuit can silence thousands who have neither the time nor the money to challenge well-funded terror financiers or the vast machine of the judicial system. What are the techniques of war, of lawfare? There are three. The initiation of lawsuits before courts in the international system, the International Court of Justice, the International Criminal Court. 2, the misuse of legal terminology to manipulate international institutions and to create negative opinions about the enemy. And 3, the prosecution of foreign nationals in domestic courts for military and civilian action. An example of each, very briefly, the filing of malicious libel suits, libel and hate speech lawsuits brought against writers, politicians, journalists. Today in the New York Times, an article about the journalist from Denmark who was sued because he put a cartoon in the paper about the Prophet Muhammad, and today the president of Germany said, you have the right to speak. But because these lawsuits, these harassment lawsuits, workplace harassment lawsuits, libel tourism, seeking good forum for suing in Britain, very easy to sue for libel in Britain because there the plaintiff does not have to prove the guilt of the accused, but rather the accused must prove their own innocence. Completely opposite manner of procedure from the United States, where we have a presumption of innocence. So these lawsuits, these hate speech cases, many of which are in Europe, in the Middle East, they sway public opinion against the United States, against Israel. And the problem with these lawsuits is they chill free speech. I will be done in 2 minutes. The next type of lawfare is universal jurisdiction abuses. And many have denounced universal jurisdiction cases where Bush and Clinton and Tony Blair have been, there have been attempts in Belgium, for example, to prosecute Blair for war crimes, as well as Jordan's demand for the extradition of a controversial Dutch politician to stand trial for blasphemy of Islam and for bad feelings about the Muslim religion. Gaza report, UN investigative report, resulted in an international outcry against our friends, Richard Goldstone, Christine Chinkin, because the report accused Israel of war crimes. Some have even argued that the Nuremberg trials could be called a kind of universal jurisdiction abuse, and LawFare. So to conclude, the abuse of the legal system, of human rights laws, and of humanitarian laws by LawFare undermines the overarching goal of world peace. By eroding the integrity of the legal system, by weakening the global establishment and enforcement of the rule of law, the manipulation of the Western court systems, misuse and abuse of European and Canadian hate speech laws, and libel law procedures can destroy the very principles of free speech that democracies hold most precious. LawFare is not a benign weapon of war. It bases its strategy on using the law to gain negative publicity for the enemy country. It is an assault on the people of free nations to exercise their constitutional rights of free speech under both international and domestic law. The LawFare users are fighting freedom and attacking those who have the right to speak and to act openly. The weapon they use is the rule of law, which was originally created not to quiet the speech of the innocent, but more to subdue dictators and tyrants. Ironically, it is this very same rule of law that's being misused now to empower these tyrants and to thwart free speech about national security and about public concerns. LawFare is an attack on the sovereignty of democratic states. It's a pun, a not-so-funny play on words, based on the shared power of the law, which is strong as the power of military might, especially when it is misused and abused. The continued use of LawFare will erode the integrity of the national and international legal systems and will, I fear, result in the increased and unfortunate use of warfare to resolve disputes. Thank you. Trying to get rid of it? How do we get rid of it? Escape. Law and war. Escape is everything. Where do you have to escape? You can't escape. We need protection. These metaphors are terrific.
Thank you.
Thank you.
Okay, first of all, I'd like to thank the organizers, and in particular Michael Scharf, for inviting me here. It's wonderful to be back here. My very first conference in the States was also here. It was a roundtable for the semiotics of law, and I'm here in the session on the historical and semiotic origins of LawFare. When I was invited to this conference, I thought I had a, well, more or less clear idea what LawFare was all about. At the time, I thought LawFare stood for the way in which all participants in contemporary wars, governments, the military, NGOs, human rights groups, all used law to pursue their own strategic ends. That LawFare was, in David Kennedy's words, the art of managing law and war together. But then I was soon to find out that that's not how the term is used mostly nowadays. I was to find out that nowadays lawfare is mostly used as an instrument to denounce people who fight particular governments using legal means. And I found that intriguing. How is it possible that one and the same concept is used for such different agendas? How is it possible that such different and even opposing meanings are attached to one and the same concept? And it shows, I think, that lawfare is a very powerful concept, that it's worth struggling over the meaning of lawfare. So what I did in my paper is try to take a few steps back and look at the, well, genealogy is maybe too big a word, but something like a genealogy. How did it occur? What are the different contexts? What are the different social practices in which the term lawfare has been used? And as the title of my presentation shows, I found it quite curious to see how it evolved. And I found 4 different meanings, and unfortunately I only have 13 minutes, so I'll need to skip the first one, from yin and yang to unrestricted warfare, although that is the most curious one. And that's the how it started in the 1970s in a book a book chapter that pleaded for peace, harmony, and love, and a balance of yin and yang in society, and then advocated a turn to the East in order to remedy everything that was wrong with Western legal culture. And then an ironic move, because then lawfare appeared in the book of 2 Chinese officers, but there was not much harmony, peace, and love going around. It's one of the most grim pictures of war that you can imagine, where actually the whole Clausewitzian definition of war is turned around. War is not seen as the continuation of politics, but society and politics is seen as the continuation of war. But I can't go into that now, unfortunately, because of time reasons, and also because if I need to select, I think the other 2 are more interesting because they will most likely appear later on in the discussions that we'll have today. So, the second one, the legalized war, that is, I think, the very first context in which the term lawfare appeared. It's the realization at the end of the 20th century, early 21st century, that the relation between law and war has significantly changed, that nowadays law is omnipresent and lawyers are omnipresent in military affairs, and that new relationships have been built between humanitarians and the military. The classical example that's generally given is the Kosovo operation, where lawyers influenced military decision-making at all kinds of levels. And this is also where Major General Charles Dunlap came up with his definition of lawfare as the strategy of using or misusing law as a substitute for traditional military means to achieve an operational objective. Now, Major General Dunlap will be presenting in the next session, so I don't think it makes much sense for me to delve into his work here now. But I'd like to stress one thing here, that at least in the way I understood it, what the term lawfare does in this context is mainly try to capture this new relationship between law and war. It's not meant as an instrument to denounce activities of others per se. Whether lawfare is a good thing or a bad thing depends on the concrete circumstances in which law is used and for what reasons. Having said that, of course, the strategic use of law still raises fundamental questions, for example, regarding the integrity of law. What is left of the normative independence of law if people all use them strategically and reciprocally know that they do so? Well, that is a question that figures prominently in the book, and that was my entrance to the concept of lawfare, David Kennedy's On Law and War. And David Kennedy, in this book, sketches how, in the past few decades, the international humanitarian law, or the laws of armed conflict, whatever you want to call them, have become kind of a common vernacular or common vocabulary for assessing, discussing elements of war, and that every participant in contemporary wars, NGOs, the military states, etc., use this vocabulary. At the same time, he argues, this vocabulary is rather flexible and underdetermined. So the net result is, according to him, that the laws of war provide the opportunity to make opposing claims in a language that is globally understood. And that, of course, fosters this strategic use of law. And what I find interesting, because one of the reasons why I was interested in setting out these different usages of the concept of lawfare was not to find the correct or true meaning of lawfare. That would be rubbish, of course, because meaning is socially constructed. So, but to analyze how a particular definition of lawfare is related to a particular way of organizing responsibility. What ways of holding people accountable are closed off or opened up by a particular definition and approach to lawfare. That is actually what is at stake for me in analyzing this. And here I found Kennedy's book particularly interesting, because what Kennedy argues is that this strategic use of law, while not in and of itself per se to be denounced, still raises fundamental concerns. One is what I already mentioned, the integrity of law. If everybody uses law strategically, and if everybody knows from one another that you use it strategically, what is left of law as a normative independent source? Legal discourse turns into a discourse of the deaf then. And secondly, he raises concern, that concern has also been raised by others, that personal responsibility for decisions regarding the lethal use of force is being replaced by legal calculus. And actually there has been some empirical research also showing that this actually can happen in war situations. Now, at first sight, those seem to be two contradictory concerns. One is law is not taken seriously enough, and the other, law is taken too seriously. But I think if you dig a little bit deeper, what is at stake here is a very important point, namely the same basic idea that humanitarians in the military and other who are present in participants in war should acknowledge the freedom to take responsible decisions on the use of lethal force, including the decision to use law as a strategic tool. Okay, now let's go to the third, what I've called reflexive lawfare. That is the use of lawfare that is, I think, most common nowadays. The use of the term lawfare to denounce activities by others. And, well, the background is pretty clear. It's the rise of universal jurisdiction, the ICC, a stronger reliance on security, and the idea that we know what it actually means and what it is, and that we know what measures need to be taken, and that using legal fora frustrate that. And that is also, well, the definition that was put in the leaflet that was sent around, the 2005 defense strategy by the United States, where the use of law is put on a par with other instruments used by the weak, namely terrorism and international fora. And I think this is a very important transformation in the way in which lawfare is used, because for people like Kennedy, lawfare was a way to capture a new relation between law and war. Now, lawfare as a term, as a label, becomes an instrument in war or in political struggles. So I think it's a very fundamental transformation here. And that is why I came up with this term reflexive lawfare, which I then would define as the use of the term lawfare to discredit an opponent's reliance on law and legal procedure. And the other one is a more fancy one, but less accurate, but that shows where the reflexive comes from the use of the term lawfare as an instrument of lawfare. And so it's actually also a kind of a lawfare, but you use the term in order to discredit the other and to say, well, yeah, it's like saying I'm neutral, and the others have a position. Now, I think there are three important ways where you can also see how this differs from the other usages of the term. First of all, generally, I mean, I generalize a little bit, so it's probably not true for every individual position, but I think the general picture is more or less correct. Generally, the use of the term lawfare is now reserved for activities by particular groups against particular governments. So there is no recognition that lawfare is an activity that everybody in contemporary wars engages in. The states, the military, and NGOs, and human rights groups, etc. No, the focus is mainly on non-governmental organizations. Secondly, lawfare is projected as something negative almost by definition, whereas in the other definition, that was not necessarily the case. It could have very bad results, but it depended on a particular context. And thirdly, I think the relation to responsibility has changed. For people like Kennedy, a term like lawfare and the whole analysis of the role of law also confronted him with his own previous efforts as a humanitarian to civilize war. And then he said, well, what has it brought us? So it propels a process of critical self-reflection. In the reflexive law affair, the main aim is not to induce critical self-reflection, but the main aim is to show that others are acting irresponsibly because they hinder a government who is fighting for a good cause. So there are all kinds of different reasons, different meanings attached to the concept. Okay, to conclude, yeah. This is not to say that the use of lawfare should be abandoned. I think the concept is simply too powerful to remain there. It's not to say either that the use of law and legal procedure can never be criticized. There's very good reason to be critical about the use of law to solve political disputes, and I've tried to do that in the article that's in the book. But I don't think that using lawfare as a label to discredit the opponents helps us very much in this respect. On the contrary, I think it blinds us to the omnipresence of law in contemporary wars and for the ways in which legal arguments are used strategically by all parties concerned. And I think it seduces us to take a too comfortable position that we already know what needs to be done and that we can discredit the other party rather than inducing a process of critical self-reflection. Thank you.
Thank you very much, Professor Stephen Brun and Professor Werner. And hand it over to you.
We will reconvene promptly at 10 o'clock. So there's a 10-minute break, coffee and food outside. The bathrooms are right to the right.
Thank you very much. Thank you. I think it's just a
Okay, fine. That's probably more logical.
And we're supposed to stay inside.
And we're supposed to say what?
Stay here. The
that's
moderator is going to be in the middle, so we're not going up to the podium.
Okay. But I'm so sure. You know, I'm not going to do slides. I was going to do them and decided not to. I had some really good ones, but
one slide. No words.
Paging Charlie Dunlap.
Charlie, this is your conference. You've been in that up and out.
Paging the man who invented the term lawfare. Is anyone? Anyone?
There you go. Major General, and he has no discipline.
Yeah.
There he is. Hey, Charlie, you're in the wrong place.
Here we go. All right. See how humble I am? It's almost biblical. I have to be called up to the big table.
You just want to stand in the back and throw darts at us, I know.
Yeah, I have some really good. I'll show you too.
Okay. All right, I think we're ready to get started. If I could draw your attention this direction, that would be fantastic. I'm Dan Malthrip. It's a real honor to be here. I got to moderate one of these panel discussions at this time last year, and it's a real pleasure then. It's a pleasure to be invited back now. I want to thank the Cox Center and all the affiliated organizations and thought leaders who have put this together. This is incredible. And I have to say that as a former English major, actually spending some time talking about the value of a single word and whether or not that word is useful or not, and can it be reclaimed for the good of humanity is very, very exciting. So here's a quick quiz for you. Which of the following is lawfare? A, is it a habeas filing on behalf of a Guantanamo detainee? B, the denial of that habeas filing. C, the manipulation of public opinion to turn attorneys for detainees into enemies. Or D, all of the above.
All of them.
So that seems to be more or less what we're dealing with here, and it seems as though this is a term that really its meaning depends on who is using it and what their ends are. So we're talking not only, as we have for the last hour, about what lawfare means, but now whether or not it's actually a useful term, and if it does in fact have value, can we grab hold of it and reclaim it? And what I was remarking to Paul just before, that what's so remarkable about this event is that given who's in this room and who's in the room upstairs, any agreement that we come to here may actually have an impact. So the stakes are actually kind of high. This is not just an idle exercise. I probably don't need to introduce everybody to all of you because you know who they are better than I do, but I'll do brief introductions now. Major General Charles Dunlap, Jr. retired from the U.S. Air Force, where he served 34 years as a judge advocate. He is a visiting professor at Duke University Law School, and he served while in the Air Force in the UK, Korea, the Middle East, and Africa, including short stints in supportive operations enduring freedom and Iraqi freedom. He's widely credited with inventing and, of course, popularizing the term lawfare, for which he is either to blame or to thank. Paul Williams, next to him, teaches law and international relations at American University's Washington College of Law, and he teaches at the School of International Service as well. He's the co-founder with Michael Scharf of the Public International Law and Policy Group, and in the course of his practice, he has assisted numerous states and governments in peace negotiations and issues of state recognition, along with some other very, very heady stuff. Scott Horton, I don't know how he manages to do as much as he does, but Scott Horton is not only a contributing editor for Harper's Magazine and an attorney working in the international arena, but he also teaches at law school, at Columbia Law School, and he's a member of the New York City Bar, where he has been leading studies of abuse issues associated with the conduct of the war on terror. And Layla Nadia Sadat, congratulations on your award earlier. She will be the Alexis de Tocqueville Distinguished Fulbright Chair at the University, I'm probably going to mispronounce this, the University of Cergy-Pontoise in Paris in spring 2011. Congratulations on your appointment as well. She's also the director of the Crimes Against Humanity Initiative and the author of the book, The International Criminal Court and the Transformation of International Law, Justice for the New Millennium. Here's how it's going to work. We're going to start on this side. Each of these gentlemen will get, starting with General Dunlap, will get 12 minutes or so to lay out their case. And then these are the more or less the pro side. Lawfare is a useful term. Over here, lawfare, useful term, not so much. Everybody gets about 12 minutes and then 3 minutes for a quick rebuttal. and then I'll have some questions for them for the remaining 15 minutes of the forum, that some of which will be directed to particular people, some of which will be for everybody to answer, but somewhat quickly. So without further ado, Major General.
Thank you very much. And before I start, I'd like to thank the organizers of this conference. It really is terrific. And Case Western, for those of you looking in on the webcast, frankly, I could not be more impressed with Cleveland and Case Western. I've never been here before, but what a terrific place, and the hospitality could not be greater. I am not going to repeat the different definitions of lawfare that have been given before. My own definition, the previous speaker did a good job at laying it out. I did want to emphasize a couple of what my thoughts were. I always considered lawfare to be the equivalent of what we call in the military an effects-based operation. And effects-based operations is not something unique to lawfare. It's something that we talk about in the Air Force in particular a lot. It's where you don't focus on a particular methodology. You focus on actions which achieve a certain effect, which will advance the commander's strategic or operational purposes. And that's what I always conceived of lawfare as being. And the term was always meant to be ideologically neutral. It wasn't meant to advance one side or another. In other words, I've tried to emphasize a lot that lawfare can be used by either side in a belligerency. And I like to emphasize how the United States has used lawfare. In the beginning of Operation Enduring Freedom, there was commercial imagery being sold of our installations. They were photographing our installations in some detail. There are different things that we might have been able to do to keep that information from getting into the hands of hostile forces, but instead we deployed a legal weapon, a contract where we purchased all the relevant imagery. And in that way, we achieved the same effect as if we had applied military means. And that's not the only way. Sanctions, you know, a lot of people decry how sanctions don't work. Well, I can tell you as a former Air Force general that sanctions were the single most important thing in debilitating the Iraqi Air Force. Not only were they not able to purchase new aircraft, they weren't able to get spare parts. So what happened in the Second Gulf War in 2003? Not only did not a single Iraqi fighter fly in opposition to the coalition's air armada, but they were physically burying their planes in hopes of the few that they had, surviving the few that they had left. In counterinsurgency, we've heard it before, you won't find a military commander who knows anything about counterinsurgency that will fail to say that the reestablishment of the rule of law is anything but a central feature of that strategy. There's all kinds of psychological reasons for it. There are studies of histories that will tell you that the reestablishment of the rule of law is critical. That's why the U.S. military is devoting so much of its legal energy to professionalizing how you do that in host countries. And when you look at the kind of threat of global terrorism that we see today, frankly, legal methodologies are probably going to be, over the long term, some of the most effective ways of addressing it, specifically unwinding the financial support. Now, you'll see in the literature that some people call this juridical warfare and so forth, financial warfare, but it's really just another form of using the law as a substitute for more violent means. Now, the New York Times just last week talked about different actions that the State Department and the Justice Department have done to, quote, ratchet up the legal pressure on the Pakistani Taliban. And they've done a number of things, designations which criminalize material support for certain individuals. And they've also deployed another legal weapon in the form of a unilateral contract that we know is a reward in an effort to get more information leading to the capture of these individuals. And I would suggest to you, people say, well, rewards don't work in other cultures and everything else. Yeah, they do, actually. And they create a psychological pressure, which is something that we should remember about the law in terms of thinking about it from the mindset of the adversary. You always, in a Clausewitzian way, want to inflict friction on that person's operations. That's why I am not disturbed by the fact that we might be going after terrorists using a law enforcement legal regime, but also going after them under a regime which is governed by the law of armed conflict. The fact that they have to defend themselves from two different fronts is bringing the law to bear in a way that resonates with military commanders, which is another point I'd like to make. When I first started talking about LawFare, the target audience was not, with all due respect to all of us, was not academics or political scientists or anybody else. The target audience was always military personnel and military commanders. I was trying to capture a way to conceptualize for them what the role of law is in modern warfare. That was the audience. And people say, well, you know, LawFare, you haven't defined it. It doesn't fit into the epistemology of political science. I don't care. That wasn't the target audience. And in the military, we are always trying to shorthand complex ideas into something that's going to be digestible into the mind of the 19-year-old. And we as lawyers need to be concerned about that. One of my big criticisms is we have now that I'm in the academy, we haven't done enough to figure out how we can communicate effectively with the key audience of the doers. LawFare was always, in my judgment, aimed at the doers. And so we have to do a better job of how to do that. And the deficiency that I see most commonly, academics and people in the world that I'm now living, they know a lot about the law. They will tell you the notes memoir, that's a legal term, isn't it?
That's good, that's good.
Notes memoir of the 1907 Hague Convention or whatever. But they're clueless when we have all kinds of people talking about drones that have never studied what a drone is. In fact, the use of the term, one of the criticisms I have for Philip Alston, and he's not the only one, is even the use of the words drones, because it conjures up this Terminator, heartless, autonomous weapon system, which it isn't. It's a remotely piloted aircraft. And let me bring up another point about that. We need to be very careful with the terminology if we want to continue to successfully access the group, meaning the doers, and make them listen. If you read Philip Alston's report on, from the UN about drones, about remotely piloted, he alludes there, well, you know, they may have a PlayStation mentality. Let me tell you something. You use that kind of language and you insult military personnel, that's the end of it. They're not even going to listen to you. And I would submit to you that anybody who actually knows the people who are operating these systems, if anybody thinks that they are so unprofessional, have that kind of cavalier attitude about killing other human beings, they don't know what they're talking about. But I see it over and over again. If you're going to practice in this area, you've got to invest the energy and the time of learning about war, about weapons, and especially about the psychology of the people who are waging it. And I do have to apologize. I didn't get my paper in on time to be in the little, but hopefully it'll be in the final version. There's other points that
you've missed your opportunity.
I've missed my opportunity. But let me just make a few other quick comments before I close. This purpose of this conference is not to discuss the Goldstone report, but let me highlight one thing that really worries me about it. Are we reaching the tipping point with our target audience? Mike Schmidt, in an article, Mike Schmidt, who many of you know at Durham University, he pulled out part of the Goldstone report about the warning that was given by the Israelis, and they dropped 2.5 million leaflets, they made 165,000 phone calls and so forth. And those of you familiar with the law of war would note, as Mike Schmidt did, that this is an astonishing amount of warning given and unprecedented in the history of warfare, but it was very much criticized by the Goldstone report. Here's my concern. What kind of effect is this going to happen on the decision makers, to wit the military commanders? And are they going to think, what's the use? We're never going to satisfy these lawyers if we do all this and we still get criticized. Does that mean we're going to devolve into some Hobbesian, immoral, illicit? No. But what could happen is that we're going to devolve into a legal minimalist. In other words, rather than encouraging commanders to go more than what the law requires, it's going to be very much of a minimalist. And when we do go more than what the law requires, we need to understand what the second and third order effects. I'm going to close with this. One of the things that self-inflicted lawfare, the NATO restrictions on airstrikes. Good idea. What did they say? Well, what were the public pronouncements? NATO said, well, you know, if there's any civilians down there, we're not going to drop a bomb. And then they later came out and said, we're not, even if there's just one civilian out there, we're not going to drop a bomb, even if Osama bin Laden is down there. Number one, I'd submit to you that that statement is very insensitive to Americans. But it's not the law. And what did it encourage the enemy to do? It encouraged the enemy to embed himself with civilians, and it created a legal sanctuary just with the effect of being any fortress that has hundreds of anti-aircraft guns. And what's the consequence been? Civilian deaths in Afghanistan, ever since General McChrystal put his restrictions, have skyrocketed. And what else has skyrocketed? Coalition troop casualties, which has done what? It's eroded the support of the publics that contribute the troops. So we need to be smart enough to think about the second order effects of when we try to improve upon the existing law. This is what I think is on the cutting edge of lawfare as I conceive the term. Now, having said all that, I'm very sympathetic to what Scott said.
Cutting into your own rebuttal.
Okay, I'll cut into my own rebuttal. Because I do want to say, I am appalled at the idea that people are using lawfare to label anybody who uses the courts as being terrorist or if not terrorists, at least fellow travelers of terrorists. That's absolutely wrong. And by the way, it's historically stupid. Because if you look at history, and Victor Davis Hanson, I know a lot of historians get hyperventilating at the word Victor Davis Hanson, but if you look at history, societies that respected liberty, that respected the rule of law, by and large, are extremely powerful warfighters. In other words, it's counterintuitive, but totalitarian regimes, by and large, do not achieve lasting battlefield success. And if you look at what the adversarial system does, it brings to bear an extremely powerful truth-finding system. And truth sharpens our focus. It makes us better. And when we become better, we become more dangerous to our adversaries who don't have that kind of system. So putting aside everything else, purely from a pragmatic point of view, we should not be afraid of litigation. Oh, people are going to sue us. People, you know, I think this country is we are the superpower of lawyering. So, I mean, I don't think we should be too afraid of, oh, somebody's going to file a lawsuit against us. Hey, take your best shot. You know, I mean, if that's what, you know, and our clients need to understand that this is part of modern warfare. And with that, I'll shut up. Thank you very much.
Thank you very much, sir. Paul Williams.
Great. Thank you, Dan. I wanted to begin as well by thanking Professor Sharp for pulling together this conference and inviting us all here to exchange ideas on lawfare. As Dan had mentioned in the introduction, Michael and I run a nonprofit, a global pro bono law firm, which advises countries on peace processes and resolving conflict through the use of law. So I engage in lawfare on a regular basis. So my job is to explain why lawfare is a useful concept. And what I wanted to do is take the definitions that Susan, Wouter, and Charlie have built upon and push them a little bit farther. My theme is that lawfare does exist, lawfare is a useful concept, and lawfare is a war worth fighting. And failure to do so as a lawyer could seriously jeopardize the interests of your clients. Just as Charlie has in mind the 25-year-olds as his audience, sorry, you're the 19-year-olds. I've got the 25-year-olds. Those that have recently graduated from law school, those that have entered the Department of State or other foreign ministries, those that are working for mediators around the globe. The notion that I try to work with these young professionals is that the gains that have been achieved on the battlefield by your client and the gains that have been achieved at the negotiating table as they fight for peace can in fact be lost in the fine print of agreements, Security Council resolutions, decisions of tribunals. And that just as it is the job of the National Army to fight for the territorial integrity of a state, the job of rebels to fight for legitimate self-determination, and the job of peace delegates to fight for a lasting peace at the table, it is certainly the job of lawyers to engage in both defensive and offensive lawfare to protect the interests of their clients. I want to point out 3 similarities between legal mechanisms and legal processes and warfare that I think support this notion that lawfare is a useful concept. The first is that they oftentimes pursue the same objectives. The second is that they have a broadly similar theoretical approach. And the third is that lawfare, as part of a conflict resolution approach, is oftentimes fought before the hot conflict, during the hot conflict, and after the hot conflict. And that in fact you find much more of a temporal engagement of lawfare than you do in warfare in the process of conflict resolution or dispute resolution. Looking at the first takeaway, that they accomplish the same objectives. We've all read in the various papers that Charlie and Scott and Susan and Wouter have put forward about the notion of Clausewitz and that war is simply a continuation of politics by other means. I think lawfare plays in this in 2 situations. One, international law and the use of international legal mechanisms is also a continuation of politics by other means. But importantly, it's also a continuation of the objectives of the war fighting by additional means. If we look at the 3 primary interest groups and the objectives that they're trying to accomplish, I think it's important for lawyers, their clients, and mediators to think of the negotiation, so think of the concept of lawfare and how it applies in these negotiations. And I've been struck in my work in about 24 peace negotiations over the last decade and a half of the sort of lack of understanding of these key players. Oftentimes, young lawyers, since I teach as well, I can talk about my 25-year-old alumni, are seduced by this neutral, and Wouter touched on this earlier, the law is neutral and everyone else has positions. And the worst thing is for my young lawyers and my young Foreign Service officer friends to believe that the law is neutral and the legal mechanisms are neutral and that only the parties have mechanisms or parties have positions. Clients are clients. We work for the Darfur rebels. We work for the Southern Sudanese. We've worked for the Sri Lankan government. Clients can oftentimes be seduced in this notion that, oh, we'll take our political disagreement, our disagreement over the use of force, and we'll just put it to a neutral legal mechanism. Or we'll just apply neutral legal principles. Okay, we can tick that box and put it over there. While the other side is actually fighting a very aggressive campaign of lawfare, and if your clients see it as neutral and just put it off to the side and move it off and out of the conflict resolution environment and into the legal environment and get back to negotiating the more serious issues, they will find that there will be a rearguard action that they will have to fight. Or if they fail to fight, it'll be devastating. I've also been deeply surprised that mediators oftentimes fail to acknowledge that the parties in a conflict, simply because they've come to Geneva or Doha or Rambouillet or Paris, that they've put aside the warfare aspects or that they've put aside their objectives that they were seeking to fight on the battlefield. They haven't. They bring those objectives into the peace palace. They leave their guns at the door, but they bring in their lawfare fighting capability. They switch their guns for their pens, but they are still engaged in a very aggressive action to accomplish those same political objectives that led them to the battlefield. In working with the 25-year-olds and trying to think through how one conceptualizes lawfare, I find it very useful to draw parallels, and getting back to the topic of this panel, or the title of this panel, useful to draw parallels to the way in which military strategists approach a conflict. You have a strategy, you have an operational plan, and you have a tactical plan. More importantly, your opponents have a strategic, operational, and tactical approach to their lawfare. A prime example of this is the Burmese junta. And here you have a melding of essentially the military and the political establishment. The Burmese junta has a very sophisticated approach to waging lawfare, both against the opposition, the Burmese opposition, and against the international community. They engage in constant operations against Aung San Suu Kyi through a string of legal cases against her, spent most of her time post-1990s elections under house arrest or in detention because of these constant lawfare attacks against her. They have also waged a very successful tactic against the international community, the old Trojan horse approach. They announced a little while back a new constitution, and they were going to bring democracy to Burma through this new constitution, which of course simply allowed them to change their military uniforms for suits and ties, but essentially continued the regime. And this Trojan horse was welcomed by the international community, changed to a period of engagement, backed off on the economic sanctions, backed off on the political pressure, and only recently has the international community realized that this was a very successful tactic of warfare. And now the international community, as Professor Scharf mentioned in his introduction, is pushing back with a UN Commission of Inquiry into possible war crimes and beginning to try to delegitimize. The Burmese government in exile has also, until recently, only pursued simply tactical, pinprick legal strikes against the regime in Burma, but more recently they have developed a strategy which includes a full court press, challenging the credentials at the UN, challenging the legitimacy of the Constitution, thinking about holding parallel elections, and reconstituting themselves to bring new energy into their democratic movement. There are also offensive and defensive. We'll just point out here the International Court of Justice case launched by Serbia against Kosovo. After losing on the battlefield, they then pursued a legal offensive at the International Court of Justice, which they also lost. But it was clearly a full-on objective of protecting the sovereignty and territorial integrity of Serbia. First they tried the military, didn't work. Then they tried the International Court of Justice, that didn't work. The Kosovars had been involved in a very substantial effort at defensive lawfare for a period of time. They had spent 8 years building up their resistance against what they knew would be a legal siege following the military siege by Serbia. They had developed standards before status, they had protected human rights, they had developed a court system, they had innumerable elections which met international standards. These were their old-fashioned walls and trenches that they were building up to defend their own right of self-determination when it would subsequently be attacked by the Serbian regime in the legal battlefield after the military battlefield. The third point, and I'll use my last 2 or 3 minutes to address these, is that lawfare can be conducted before a conflict in order to avoid it. It can be conducted during the conflict. It is oftentimes conducted during a pause in the conflict, and it is conducted after the conflict. Touching briefly on avoiding conflict. In North-South, the province of Abyei contains much of the oil of Sudan. About 2 years ago, both the northern forces and the southern forces were taking pieces of Abyei because the boundaries were undefined, and they eventually got to a point where they were facing off gun barrel to gun barrel. The international community in the north and the south worked to pitch this into an arbitration mechanism before the Permanent Court of Arbitration in The Hague. It didn't solve the problem, but it created a possibility to avoid that conflict and pull the parties back from the brink. I would point out that currently, northern Sudan and southern Sudan are engaged in a very aggressive lawfare against each other. In January of 2011, there will be a vote on self-determination for the South. It'll likely become independent. There is some speculation that this will lead to conflict. Both parties are engaged in intensive negotiations mediated by the international community to resolve as many issues, to take away as many conflict drivers as they can before that vote in January. So there's a fierce and a mad rush to conduct lawfare against each other so that they get enough of what they want out of these negotiations, and that they've set up legal structures in terms of debts, assets, membership in international organizations, treaties, so that they can accomplish their political objectives so they don't have to turn to the use of force. I'm going to borrow 1 minute from my rebuttal to tell two other stories that I want to tell. One is, as you're defending your clients against lawfare, be careful what happens in the pauses. I've just returned from Doha, representing the Darfur rebels, where they've negotiated a number of ceasefires. The government of Khartoum was quite keen on working in DDR provisions, demobilization provisions, into the ceasefire agreement, because that would tilt the balance on the battlefield, and it would degrade the ability of the rebels to pursue the use of force if the ceasefire were to expand it. And they were using the Sri Lankan model. During the ceasefire that the Sri Lankan government negotiated with the Tamil Tigers, they imposed an arms embargo, which is great, but then they also put in a legal provision that they were entitled to protect the territorial integrity. So the Tamils did not have that right. They simply were subject to an arms embargo. The government had an arms embargo, but since it had to protect the territorial integrity, it could still import certain types of weapons. To do that, which they then used in their successful military intervention against the Tamil Tigers. And one last one is, just when the war ends, that's the time that the military commanders can take a break, but not the lawyers. The Bosnian Constitution was developed at the Dayton Accords. The Serbian government had a very aggressive approach of sprinkling the Dayton Constitution and the Dayton Peace Agreement with landmines that would continue to handicap the political development of Bosnia for years to come and to lay the foundation for the potential secession of the Republika Srpska out of Bosnia and into Serbia, which was the political objective to begin with, which was the military objective, and which was almost accomplished at Dayton through very clever lawyering, which the mediators did not push back on and the Bosnians did not substantially push back on at that time. So there are various significant perils associated with failing to recognize that lawfare is a useful concept and for failing to adequately fight lawfare before, during, and after the hot conflict. Thank you, Dan.
You're very welcome. So much for rebuttal time. Scott Horton, take all 15 minutes. That's not it.
That's not it.
Do we know where Scott's?
There you go.
No.
No,
We've got a particular.
that's a little inflammatory.
That is not what Scott's going to talk about.
Definitely not. Got somebody who knows where it is.
There it is.
Scott Horton slide. There you go.
Scott Horton slide.
Ah, this is
Let's really put it up
there. we go.
one slide. Thank you, Scott.
Thank you. So this painting by Edouard Manet captures one of the most important engagements of the American Civil War. It's also one of two quite significant political paintings by Manet, and there's much more behind it. And in my mind, it offers a perfect way to approach the question of lawfare. What we're seeing here is one of the most important naval engagements of the American Civil War. It's a battle between the USS Kearsarge and the Confederate raider ship Alabama. It was fought on June 19th, 1864, right off the coast of Cherbourg and Normandy in France. And we know from contemporaneous accounts that this was the peak of the summer beach season in Normandy, that all society was there on the beach with their picnics and champagne watching the battle off the coast. Manet actually wasn't. He came a couple of weeks later to do this report, to do sketches and then ultimately to produce this painting. The Alabama had, over objections of the United States, been constructed secretly by an English firm in England and had been turned over to a Confederate crew. It had engaged in raids on American shipping. There were at least 7 separate engagements in which it had attacked U.S. Flagged vessels. Capturing and engaging the Alabama was a priority for the U.S. Navy. So when American intelligence learned that it had put to port in Cherbourg, the Kearsarge was tasked to blockade it and to sink it. After spending several days in port, the Alabama tried to fight its way out, but it was no match for the Kearsarge and it was sunk. But the sinking of the Alabama didn't end this matter. At the end of the Civil War, America tallied its losses from Britain's secret support of the Confederacy. By the way, also France's secret support of the Confederacy. And we know from Manet's writings that one of the things he's trying to document here was the perfidy of the French government, which he detested. He supported the United States and idolized Abraham Lincoln, in fact. And Charles Sumner, who was the chair of the Senate Foreign Relations Committee at that time, demanded that Britain pay $2 billion. That was exactly half of the total cost to the United States of the Civil War as indemnification for damages. Or he said, in the alternative, they could simply cede Canada to the United States. And if you go back and you look at newspaper coverage from this time, you'll see immediately after the Civil War very aggressive advocacy of this. We should wage war against Britain. We should march General Grant and his armies straight across Niagara Falls and take Lower Canada, which was essentially unprotected. Horace Greeley's New York Tribune was a major paper advocating this view. And in fact, there was a considerable movement in this direction. There was something like a quasi-war between the United States and Britain in this time. In fact, 8 articles published in Harper's Magazine on this subject, which is more articles than we've devoted to the Iraq War, by comparison, for instance. In the end, however, the war party didn't win. A different group raised a different approach to this. And this was an alliance of lawyers, ministers, and politicians. Then they were referred to as the American Arbitration Movement. Later, they came to be known as the International Law Movement. They put forward the idea that the American claims against Britain should be submitted to binding arbitration. That idea won out with the United States. And after considerable negotiation, we finally persuaded Britain to agree. The arbitration convened and gave a damage award of $15.5 million to the United States against Britain. That would be something more than $1 billion today, but at that time a completely unheard of sum of money. In fact, the British Chancellor of the Exchequer said it would tax the British Treasury to pay this award, although ultimately pay it they did. But this was a decisive step in American history. First, Britain, which had been something like the hereditary enemy of the United States up until this point, began to develop a completely different relationship with the United States. It began to become a close ally. Second, in the following 50 years, American administrations of both parties, but principally Republicans, began to aggressively advocate the notion that arbitration should be used as a means of resolving differences between nations and between nations and private parties as a tool for avoiding violent conflict. They also began to advocate the idea of the international codification of rules of law which would guide this arbitration process. And this led, really under American leadership, to the formation of the International Law Association in Brussels in 1873, the year after the award, and to the commencement of the Hague process, which began to codify the law of nations, and particularly the law of armed conflict. In 1912, for instance, the Judge Advocate General of the Army presented a briefing to American legal scholars in which he showed with charts that, in fact, the end result of the Hague process had been the codification of American ideas of the law of nations and the law of war. In fact, he traced almost every major provision of the Hague Convention on Land Warfare back to rules that had been issued by President Abraham Lincoln. And in later years, we saw the United States continue to play a lead role in this process of international law formation and international dispute resolution. We saw President Theodore Roosevelt receive a Nobel Peace Prize for brokering the peace between Russia and Japan following the 1904-1905 war, for instance. This is a proud legacy of the United States, a legacy that was forged by Democratic and Republican administrations, and a legacy with which our country was strongly associated coming into the last century. Then we come to the Bush administration's 2005 National Defense Strategy, and I quote, "Our strength as a nation will continue to be challenged by those who employ a strategy of the weak using international fora, judicial processes, and terrorism." It states in stark neoconservative ideological terms. Note the equation of international fora, judicial processes, and terrorism. In other words, turning to courts for the enforcement of legal rights, appeals to international tribunals, and terrorism are seen as the elements of a single consistent enemy strategy. So this marks a repudiation of more than a century of American policy promoting the use of the international legal process as a means of resolving disputes, and it marks the emergence of a neocon doctrine of lawfare. And that's what I want to talk about today, because I'm in the awkward position of having two very eloquent speakers present an affirmative with whom I completely agree. Neither Paul nor Charlie has said anything I disagree with. But I'm afraid that the vision of lawfare that I think Charlie very eruditely presented has been hijacked effectively. And this term really is being used heavily today by neoconservatives. What's their object? I think the neoconservative vision views international law and the international law movement itself with contempt and disdain. They believe that it would unduly constrain the actions of America on the world stage. And so, but rather than attack directly international law, which people like John Bolton still do when he talks about demolishing the top 10 stories of the United Nations, for instance, they much prefer a softer target, and that's lawyers. I mean, what could be a juicier and plumper target for the American public than lawyers? And they have done this. Now, I want to, so I really must say I completely embrace the view that Votaverna took this morning talking about this and the opportunistic use of this term. And I want to say there are a number of examples that will show how this was used and the results of its use. But in the United States, there's one we should focus on, and that is Guantanamo. The term lawfare was used aggressively by certain figures inside the Department of Defense. And it was used, by the way, attacking, most often than not, members of the JAG Corps, also within the Department of Defense. In fact, some people very close to Charlie, I think, were some of the prime targets of it. And it was used to suggest that these lawyers were simply continuing the jihadist warfare through another means. They were effectively aiding the enemy. Pro bono lawyers who supported the effort were being attacked. Appeals were made to their corporate clients to drop them by Cully Stimson at one point, for instance. And there were similar attacks on Fox News and the Wall Street Journal. But now if we cut through to the end, we're coming close to the end of the process at Guantanamo, and what do we see? 600 of the 800 prisoners at Guantanamo have been released. The last 200 remaining, most of them are pursuing their cases with the assistance of JAG counsel for habeas corpus. And if we look at the current scorecard, which fluctuates from week to week, we're seeing between 2/3 and 3/4 of those resolutions before largely conservative district court judges in the District of Columbia going in favor of the detainees. So were the claims that were being raised bogus? No. Was the position of the Bush administration honest to the law? No. It was not. And 3 out of 3 visits to the Supreme Court, 3 out of 3 lost before a Supreme Court that is viewed by legal scholars as the most conservative in the last century. That tells it all. Thank you.
Thank you very much, Scott Horton.
I'd like you to change the slide back to the original conference slide.
If I can find it, I will.
Or maybe Tim can, the one that has the courthouse on it. And where will the time be shown?
In the back there, gentlemen.
You'll just go like this. Great. Okay. Not that one. No. The conference slide. The one on the. There you go.
Box lunch is available across the hall. Yay!
I'm not sure if that was part of my presentation. Well, thank you so much to Michael Sharp for inviting me in spite of my protestation. I guess I'm responsible in some way for the title of this panel, because when Michael wrote to me, I said, well, I'm not sure this is a very useful term. And he said, great, that's what you're going to talk about. So my job, I think, is to be the skunk at the garden party. And I heard Samantha Power once say that's the human rights lawyer's job, is to be the skunk at the garden party. And I'm afraid that's kind of my job here today as well. So in my view, lawfare is either a meaningless term because everybody's doing it, which I think actually is the way Charlie Dunlap is talking about it now, and even Paul Williams, or if it's meaningful, that it has taken on a certain meaning, that meaning to me is objectionable. And in either case, I conclude that it's not a very useful term and certainly couldn't generate a set of principles that would usefully guide us in thinking about law and international relations. So I don't need to go into the history. Obviously, Charlie Dunlap's here. I'm very honored to be on the panel with you again and to talk about something that really he created. But perhaps inadvertently, I think, by popularizing the notion that terrorists were using the rules of humanitarian law, domestic law, and human rights law to gain improper advantage over the United States, the term has now morphed, and others have picked it up and redefined it in a very contentious manner to suggest that any use of the law by a so-called, quote, adversary of America or Israel is improper in a form of lawfare. And this really picks up Wouter Werner's definition, which is a very negative one. I even discovered in my research for this paper that there's something called the LawFare Project. And they had a big conference at Columbia Law School at which the dean spoke. And at that conference, which John Bolton also attended and spoke at, there was very, very little that could be talked about in terms of the Alabama arbitration or any sort of neutral use of law by America's military or proponents. It was all about we've got to get the enemies of Israel and the United States. They're using law as a weapon against us. And I won't go into the whole thing. You can look it up, but they talk about human rights litigation, the Wall advisory opinion, cases involving universal jurisdiction, as things that hinder the ability of democracies to defend themselves against terrorism. This is also reflected in that 2002 and 2005 National Security Strategy and National Defense Strategy that Scott referred to, that we are being challenged by those who employ, quote, a strategy of the weak, using international fora, judicial processes, and terrorism. Now think about that, the strange conflation of the word terrorism with the words judicial processes and international fora. That's pretty worrisome. Since when is filing the lawsuit the same as mounting a violent and bloody attacks on civilian objects? It's a false equivalency, and quite frankly, it's pretty outrageous. Moreover, the irony behind the theory and contention of the LawFare Project is not lost upon anyone familiar with the approach to international law and human rights that was articulated during at least the first 6 years, I'd say, of the Bush administration. From 2000 through 2006, White House lawyers, Office of Legal Counsel, was penning memos trying to redefine legal norms in a way that would make them more amenable to what were seen as U.S. policy objectives. Having failed, at least in part, in that objective, because those were seen as objectionable, now the attack is on the law itself and the lawyers, as Scott has referred to. So I didn't know what lawfare was when I started this project, having complained to Michael that I didn't even want to do this project, so I looked it up in the dictionary. It doesn't appear. A Google return shows 44,000 results, so that's pretty impressive, Charlie. No etymology. No etymology in the Oxford English Dictionary, nothing at dictionary.com. But Hein Online, that is the legal journal that scholars can access, shows 149 results. And this is kind of funny. The first one is a 1957 article regarding divorce, which says that the canton, clearly reduced in status, is still as a state withstanding in court to wage lawfare on behalf of its folk. The next result was a 1983 book review referencing a courtroom advocacy tactic labeled as guerrilla lawfare. From 1990 to 1999, all 10 references to lawfare were advertisements for discounted airfares for lawyers. I liked that.
That's what I really like.
And in early 2001, anthropologist John Conneroff used the term lawfare to describe a coercive legal tactic used to dominate colonized peoples. Well, the term has multiplied since Charlie Dunlap's famous usage, and now virtually all the hits you will get in Hein Online are in military journals or involve military or international law contexts. this is a part of what the LawFare project is about. And the LawFare project defines it, which I think is really what we're talking about today, as the use of the law as a weapon of war, or more specifically, abuse of law and legal systems for strategic, political, military ends, as a tactic waged by the enemies of Israel and the United States as a way to undermine democracy and the rule of law. And I'm quoting. The two principal directors, Brooke Goldstein and Aaron Meyer, use the term legal jihad for LawFare and call it a synonym for Islamist lawfare tactics. And indeed, the comments of many LawFare proponents share not only a perfectly respectable pro-Israeli perspective, but have a less respectable, decidedly anti-Muslim sentiment as their subtext. And even the brochure for this conference, I have to say, identifies the Goldstone report as a problem, but ignores the actual human suffering inflicted by Operation Cast Lead, to which the report was a response. Okay. I'll go to my conclusion then. I have a couple minutes. So what does this lead us to? This isn't what Charlie Dunlop was talking about, and this is not what he articulated in his paper today. But this is what LawFare as currently used is really about in the United States. And it's objectionable. In all societies, a tension exists between the human rights of individuals and the needs of public security. And this is as true for international law as it is for domestic law. And obviously, the architects of international humanitarian law and international human rights law have to be aware of and balance these tensions, just as the courts and the legislature have to strike this balance in municipal law. So while it's perfectly appropriate to challenge a particular legal provision and suggest amendments to it or modifications, or say, you know what, it's not really working, suggesting the use of the law itself is the problem is objectionable. The image of the brochure for this conference has pictures of soldiers aiming their guns at the courthouse. And the courthouse looks a lot like the United States Supreme Court, at least to me. This image may suggest to me what LawFare is really about. It's an effort to attack and dismantle legal norms and even legal and international institutions in order to promote the efforts of America's military and perhaps Israel's. In that sense, it's not really about law at all. It's not about international dispute resolution. It's a crude policy argument that poses a frontal challenge to our constitutional system, as well as the specific rules of law, international human rights law, and the international legal system, and even U.S. constitutional rights like habeas corpus. The notion of LawFare may make for good television sound bites or a good conference title, but to me, it substitutes sound bites for careful and probing reason analysis. Through innuendo and sleight of hand, LawFare advocates equate judicial processes with terrorism, thoughtful and probing investigative reports with attacks on state security, and petitions for habeas corpus with war. Aren't we better off using law rather than bullets to resolve our disputes? Charlie Dunlop did not advocate for this distortion, but as my little survey shows, it was easy to get there and perhaps predictable that the popularization of the term in the military context could have this result. For even his own discussion of LawFare has a tendency to see individuals fighting the United States as inherently less deserving of legal protection than U.S. citizens and residents. And he suggests, as do more extreme proponents of LawFare ideology, that the U.S. and Israel are suffering military disadvantage because of the application of humanitarian law to a particular conflict or to the invocation of human rights norms to protect individuals. So the remedy to these disadvantages is either to change the law or remove the individuals from the protection of the law. The latter solution runs into serious moral objections, given the inherent sanctity, dignity, and equality of all human life, and so it's unsurprising that most lawyers don't like it. So LawFare, and I'll conclude with this, advocates appear to be waging a public relations campaign, not really making legal arguments, in my view, which makes our topic today puzzling. Are we supposed to develop a theory of LawFare, LawFare rules, propose amendments to the Geneva Conventions to exclude certain people? The purpose is unclear. LawFare advocates attempt to portray strong parties, like the U.S. and Israel, for example, as victims suffering at the hands of weaker parties, and particularly in the ugly theater of Mideast politics, hope that LawFare will help bring them public sympathy. But at what cost? Arguing that the law and those that use the law are the enemy has a dangerous ring to it and corrodes respect for the rule of law more generally. Law is created by the state, after all, and an attack on the law is, in a sense, an attack on the foundations of society. That's what lawfare really is about, and that's why I don't think it's a particularly useful term. Thank you.
Thank you very much, Layla Sadat. So we have about 15 more minutes, and there are a number of questions that have basically surfaced. And Layla, you've really put your finger on, exactly what this is about. Is it worthwhile trying to reclaim this term? I'm scratching my head wondering why nobody from the LawFare project is on this panel, but perhaps they were unavailable to join us today. I guess the question becomes then, I don't think there's a whole lot of disagreement here at all. In fact, I think everybody agrees that these practices exist and something perhaps should be done about it, but what then? Charlie, you launched this whole thing about a decade ago. What should be done about the distortion of an idea?
Well, a couple things, I think. Number one, we need to recognize that it has been distorted and it has been hijacked. But what do we do when somebody is hijacked or somebody is taken hostage? We launch an operation to go after it and to destroy those who hijacked it. Perhaps a little hyperbole there, but what I think we ought to be doing as lawyers, we shouldn't be throwing the baby out with the bathwater or shooting the messenger or whatever you want to do in terms of lawfare. We ought to go after those who seek to demonize those who are legitimately using courts and legal means, even if it's in a matter, even if we have a different perspective. I do have a different perspective on the mixture of human rights law and law of armed conflict. I think that's a dangerous concept, but I don't put myself in the category of, I certainly don't attack our defense counsel who are representing people in Guantanamo as being somehow un-American or unpatriotic. And I do have to tip my hat to Scott Horton, because way back when it was not popular to stand up for the military lawyers, he was there. But this is what we need to do. We need to be, just because a weapon is being used wrongly, it doesn't mean that we condemn the weapon. What we ought to do is condemn those who are abusing the weapon in the way that they're characterizing those who seek to use the system. And we're pretty good at doing that. This is why I can't get over the idea that, oh my God, people are filing these lawsuits and we're all upset about this, as if this hasn't happened in the commercial world, in the tort world, or anything else. And we've come up with some pretty powerful, what's that rule where you can, Rule 13 or whatever it is in civil, Rule 11, where you can crush some law firm for filing so there's ways of dealing with that. And that's what I think we as lawyers need to start talking about it. And here's what we need to prepare ourselves for. I would submit that right now, and people in this audience will disagree with me, it's not unpopular, frankly, to represent a detainee. It's almost chic. But here's the challenge for us as legal professionals. When the next act happens, public opinion will switch like that. And that's when we're going to have to stand up and say, wait a minute. You remember, we made this mistake before about overreacting, and it may be the lawyers who are among the very few, and it's not going to be popular, because when the JAGs first made the objections, the interrogation techniques, that was back in 2002. And let me tell you something, enormous pressure was brought on people. But that's when your professionalism, you have to tap into it. And it's not going to be easy. That's what we need to prepare for. But I don't think that the answer is throw out the term lawfare. I don't think it's practical. And I think we just need to rescue the hijacked.
Rescue a hijacked concept. Scott Horton, you've written about the LawFare project, and Layla has identified them as sort of the central players in the hijacking of this concept.
In the second phase.
In the second phase. What's to be done? Would you agree with the Major General?
Well, I absolutely do. I mean, I'll say I think integrity of the process is a key question here, and that is, you know, if we value our legal process, we have to ensure that it operates properly. And as I saw the way the term lawfare was being used in the first phase, the Guantanamo phase, I'll call it, it was really being used to manipulate and distort the process. I started a study of what was going on with defense counsel in Guantanamo, and I switched about halfway through to studying prosecutors and judges, and I discovered, you know, hard as some of the defense counsel had it, I thought the prosecutors had it much worse. They were really supposed to be out there exercising independent professional judgment, and I found talking to them, always off the record, you know, that, you know, they were placed under immense pressure to do things that clashed with their professional judgment for political reasons. Ditto with the judges. And I think that's all now come out and has been pretty well exposed. Well, it matters to us that the process have and show integrity. And I think lawfare was being used as a concept to undermine and politicize it. Second thing I think is that lawfare in that phase was being used basically to avoid discussion of the underlying policy. That is, issues of treatment of detainees, for instance, or today, the Goldstone report. You know, I think it's perfectly fair to have a deep engagement and critical discussion of the Goldstone report, but I found when I have attended the Lawfare Project's functions and talked to people who were involved in setting them up, that know one of the major purposes is to avoid actually engaging in discussion of that report. One person told me, well, we were instructed actually not even to quote from it. You quote from somebody who's criticized it, which is, you know, an intellectually dishonest process. I think when a United Nations report is issued, when a rapporteur's report is prepared, that's intended to provide a basis for discussion with the government that's criticized. And an intellectually appropriate response is to go ahead and engage. It's not a judicial determination, but it does raise subjects and questions that should be thoughtfully discussed by a government and not just smacked down by dismissing these things as acts of lawfare.
Layla, what would you suggest as an alternative?
Well, we have a very nice term called international conflict and dispute resolution, which is
lot
really,
longer than
it's
lawfare.
a lot longer, but it's what the Alabama arbitration
won't get that.
was, and it's what Paul Williams is talking about. I think Charlie really hit upon something when he said, I want a term that young people, you know, that live in this Twitter, I don't even know what it is, world.
That's the correct term.
So I want something that's more understandable, but the difficulty with shortcuts is they also shortcut analysis, right? So, you know, the longest journey is the one that starts with a shortcut. And so that's what we've got right now is we have, if you look at these Google things, and we did this big search on High Online, virtually every use of the term now is a use that employs this sort of pernicious, they're the enemies and they're using the law and we should stop them from doing that. So now I don't have a remedy. You know, the genie's a little bit out of the bottle. And maybe this conference is a little bit of a remedy to talk about it. But I think that the proponents of the LawFare project are very sincere in believing that their view is the correct view. So I'm not sure that I have any control whatsoever about what they think and their use of the term. They've appropriated the term. You can look on the website. They're having a big conference at Columbia Law School. I think
It was at the New York County Lawyers Association.
Oh, sorry. It was just the
Our
spoke.
dean convened
Our
it.
dean convened it. Right. Okay. So I think there's very little. I mean, Charlie has written in the Yale Journal of International Affairs a little bit of a piece saying, "Hey, this is not what I meant," but that's not getting the kind of play or money that this other uses.
So you need more of that in, say, and even beyond Harper's Magazine, perhaps. Paul Williams, the central to some of this is the notion that there may be illegitimate abuses of the law and of the courts. Who decides what's legitimate and what's illegitimate, besides public opinion and those seeking to sway it?
Recently, the United States Supreme Court, and this is something that I wanted to pick up on in sort of using the sort of rebuttal question to agree with Scott and Layla. And to push it a step further is the neocons have hijacked this term, but unfortunately, like many other ideas hatched in the previous administration, it has been continued by the current administration, which recently argued successfully before the Supreme Court that it was a crime to provide peace-building assistance, which includes legal assistance, to prescribed actors, which are any number of groups on the Office of Foreign Assets Control at the Department of Treasury, some who have agendas against the United States, and some simply who are benign vis-a-vis the U.S. But it is now a crime to provide legal assistance, as well as traditional mediation and peace-building assistance, if you're an American citizen, to any of these prescribed actors. So it's this effort to limit what is seen as lawfare. And so you have this perverse notion that if there's a group that is interested in coming out from the wild and engaging in a peace process, it violates U.S. criminal law to provide them assistance to put down their weapons and join the process. And that's what I'm worried about in this effort to sort of push back on lawfare, rather than simply say, look, it exists just like a weapon. Sometimes a weapon used by a police officer can be used in an appropriate way to stop a crime. Other times it can be used by a criminal to commit a crime. The weapon itself is neutral. The use of legal mechanisms is neutral. Sometimes it's abused, sometimes it isn't. But fight the lawfare just like we fight our wars, according to the rules, as opposed to trying to deny it.
Do we risk prolonging conflict by making it illegal to help one of the parties in the conflict?
Yes, the best way of resolving a conflict, we always talk about frozen conflicts, intractable conflicts, decades-long conflicts. 7 out of 10 conflicts are resolved at the negotiating table. Only 3 out of 10 conflicts are resolved on the battlefield. By closing off that door to those 7 out of 10, you're trying to push all of the conflicts into being resolved in the battlefield.
And Charlie, what responsibility does the Department of Defense bear in changing and reframing the concept?
Well, the Department of Defense doesn't have an official, I don't think you'll find any official doctrine that uses the word lawfare in it. So I'm not sure what DOD would do, but I do think that, and I'm not here to defend the LawFare Project or Brooke Goldstein or anybody else, but let's not be afraid of fierce advocates as long as they're following the rules. We ought to crush those who don't follow the rules. But I think that this case is very disturbing. I think we need to explore it more, because we ought to be encouraging, if we believe in the adversarial process, then, and the power that has, that we ought to encourage even shrill advocates of one side or the other, as long as they're playing by the rules.
Well, I guess then the question is, why aren't there leaders in the Department of Defense saying, wait a second, you're putting American lives at risk by prolonging conflicts and denying legal representation to parties to a conflict?
Well, what is the role of the Department of Defense in essentially a political question? That is a different question, and I'm not sure that the Department of Defense ought to be taking the lead in that within our government. But having said that, I think that we need to study the case and make sure that we understand exactly what it's saying, and it doesn't have the implication of criminalizing legal representation, because if we believe in the adversarial process, we want powerful representatives on both sides. I am very much of it. And that's, in fact, it's my criticism of some other legal systems that are not adversarial, because I don't think human nature is such that you really get to the truth without powerful, that clash of powerful ideas is what produces the truth.
If the DOD can't do it, could a group of, say, retired major generals do it?
Well, that's a whole nother conference, but I will tell you, the role of retired officers is being changed. I've been asked to write something on the legal aspects of the roles of retired generals and what should they have to say. My basic view is we don't want a society where what generals, active or retired, are thinking is kept secret. Mm-hmm. That's not a good thing for democracy, in my judgment.
Scott Horton, who would you see as the influencers, the key influencers who can rewrite how these rules are applied, or rewrite the rules themselves?
I think we have to look at it at several different levels. But, of course, I think some of the arguments that are made about lawfare, a lot of them deal, for instance, with libel. And it's argued that, how oppressive it is that we're being sued or tested under libel statutes in Canada or Great Britain for making these statements, and the people on the other side are friends of terrorists. And I think you have to step back and think, so this is assuming that our entire court process or the British or the Canadian court processes don't work, they can't reach a just result, and we hear an argument that, well, it's economically oppressive because we have to pay lots of money to defend ourselves. Well, actually, most courts outside of the United States have a rule under which the party that loses a suit gets settled with the cost. You know, we don't have that system. So actually, most courts are fairer in addressing that very problem. But I think, you know, there are some fundamental policy questions which get resolved through the legislative process. And I think with respect to all these issues that have arisen about the military justice system in particular, we have a grave problem with that. We have a grave problem because I think it's important to the United States that that system have integrity, that it operate according to principles of justice, and that it be perceived that way. And I think as a result of what's happened over the last 6 or 7 years, our military justice process has been horribly tarnished around the world, and that's got to be changed. And I think it's been tarnished by very, very aggressive efforts to politically game or spin it. And I think it's really important to stand up for the integrity and independence of that process, and nobody's going to be able to play a better role in that than people like Charlie Dunlap. No, I think it's retired military officers, retired JAG officers who understand the system and can explain what happened and what was wrong.
Layla.
I don't really have a solution for this issue of the LawFare project and how to discuss this, but I think it is worth keeping in mind that if you look at the last 50 or 60 years since the development of the post-World War II international legal system, there have been some terrible conflicts, but nothing on the scale of what we saw in the prior 50 years. And so the rush to court is a whole lot better than the rush to war. The United States has had military adventures since they're in terrible wars with loss of life, as have other countries, but nothing like the scale that we saw in World War II or World War I or the wars in the prior century. And that's why I think the irony of the LawFare project and the shrillness, sort of the shrieking hysteria, is really not in line with the reality of the situation. And that's, I think, very difficult. The internet has a magnifying phenomenon, and so you get all these hits because you're really stirring up a lot of fear and upset and, oh my God, terrorists are getting loose and this is happening. And yet we live, for the most part, in an extremely safe, for us in the United States, in an extremely safe and fairly ordered world. And that doesn't mean there aren't issues. Israel obviously has bigger security problems because of its situation and in that tension, but that's not the U.S. situation, and so the hysteria is completely out of line with the reality. So I think more courts, more law, more settlement of disputes and resolution of conflict through the adversarial process, through a great military commission system, through the ordinary processes that we as Americans really have come to believe in, and since the Alabama arbitration have convinced the international community to believe in.
More LawFare. Just don't
More
call it
LawFare.
LawFare. Okay, well, we'll probably keep calling it LawFare for the rest of today and tomorrow. We started a little bit late, and we're ending almost on time. There's about a 13-minute break, and then the next panel begins at 11:30, LawFare and War Crimes Tribunals. Take a break, enjoy the coffee, tip your waiters.